The professional responsibility essay from February of 1997 is another tricky and difficult PR question. And the reason it's difficult is because we are dealing with an attorney who is facing conflicts not between clients, but between ethical duties. The good news is the call of the question organizes our answer for us. Take a look at it. Question 1. Should attorney have told the police officer anything about the shoes and the ring? Discuss. Well, we know that attorneys owe criminal clients a duty of confidentiality. Although, come to think of it, we also owe our civil clients a duty of confidentiality. At the same time, we have a duty of candor that we owe to the tribunal and to the system of justice as a whole. So, although my short answer to question 1, without even reading the fact pattern, is no, we realize that it's quite possible that the attorney will face a conflict in the different ethical rules that govern the attorney's conduct. 2. Should attorney tell the grand jury that David is threatening to burn the scraps of the shirt? Discuss. Well, presumably the shirt is evidence. Still, one is leery about advocating that an attorney act as an arm of law enforcement in testifying before a grand jury. We'll have to look at the facts. 3. May attorney tell the grand jury anything about the other events described above? Discuss. Here, we will use the facts as our organizing principle. We will focus our attention on each fact and ask and answer the question, can the attorney tell the grand jury about it? Then, finally, question 4, should attorney continue to represent David? Discuss. Here, we're going to have to examine the relationship between the attorney and client and see whether or not it is irretrievably broken down. If it has, the attorney should withdraw. If not, it will be a closer call. So, armed with the knowledge that this 4-part call of the question allows us to organize our answer and to address this problem really as a series of 4 short answer questions, let's go to the top and have a look at the fact pattern together. In paragraph 1, we meet the client, David. He is arrested and he is charged with murder and robbery. The defendant makes a phone call to attorney, a member of the California Bar. Attorney comes to see David at a small rural jail and agrees to represent him. All right, so we've had one meeting. No ethical problems appear to be raised by the meeting. The client calls the attorney shows up and meets the client in jail. They agree about representation. So far, so good. We know that the attorney is representing a criminal defendant. We know that the full panoply of legal obligations and ethical requirements attach at the moment of this meeting, even before formal representation is agreed upon. One of these initial client meetings is protected by the attorney-client privilege, and the other legal protections afforded to clients, even if subsequent to the meeting, no formal relationship is established. In paragraph 2, we find out about the in-jail interview. David confesses to the killing and indicates that he stole the victim's shirt, shoes, and ring and was wearing all of them at the time of his arrest. Well, this is about as intimate a disclosure as a client can ever make, a full confession to the crime. Certainly, this confession is protected by the attorney-client privilege, and one would hope that everyone would understand that this duty of confidentiality is far more important than a duty of candor to the tribunal. If there is anything sacrosanct about an attorney-client relationship, it is that the attorney cannot disclose confessions made by the client about past crimes. Next, the client tells the attorney that he, the client, had hidden the shirt and shoes in the jail cell and that he had thrown the ring out of the cell window into a trash can behind the jail. David is now bare-chested, bare-fingered, and bare-footed. One would expect he would be issued attire in custody, but we will set that little bit of realism to the side and continue. In paragraph 3, the attorney lives up to the attorney's obligations. He tells the client not to hide or destroy evidence, and the client reluctantly agrees. Attorney then leaves the interview, goes behind the jail, and looks into the trash can. The trash can is empty except for the ring. At this point, the attorney hears a noise, looks up, and saw David throw a pair of shoes out of the cell window. So, the noise also attracted a police officer who discovered the shoes in the ring. The police officer asked the attorney what he knew about the shoes in the ring. This is the first call of the question. Attorney refuses to tell the police officer anything about them. And you know what? I think that's exactly what the lawyer should have done. The attorney is not an agent of law enforcement. He correctly advised his client not to destroy evidence, and when the client threw the shoes out of the window, the attorney's obligation is to remain silent. Next, the attorney goes back into the jail, speaks with the client again. At this point, the client indicates that he had torn the shirt into strips and that he plans to burn those strips. The attorney tells the client not to do so, and David insists that he will burn them. One wonders what kind of a jail they're running here. A defendant can throw evidence out of the window and then burn other evidence. Again, we are dealing with the bar exam, not reality. So we move on to the grand jury. The attorney is called before the grand jury investigating the murder and robbery, and then we get the call of the question. We are asked what the lawyer can do consistent with his ethical obligations. I think this is a pretty interesting fact pattern, actually, and to my way of thinking, some of the more complicated PR questions involve criminal defense lawyers. So, take a look at the way that I have organized an answer to this question. You will see that with regard to question 1, I talk about the competing duties, the duty of confidentiality that a criminal defense lawyer owes his client, and the duty of candor that an attorney owes law enforcement and the tribunal. These are in almost perpetual conflict, and the quick bottom line is the duties to the client usually will trump the other duties. Next, we are asked about the scraps of shirt, and I indicate that what the attorney did, instructing the client about how the client should not do it, we reach a conclusion. Next, we focus on the grand jury testimony, and here I organize internally based on the facts. And it seems to me that the grand jury is going to ask about everything. So, first I have a section about the initial meeting between the attorney and client. Next, a section about the attorney's encounter with the police officer. Then I reach a conclusion. The fourth call of the question really is just a short answer question. I can't think of a way to break it down any more for internal organization purposes. So, this is a fact pattern that is pretty easy to outline and one that requires meticulous attention to the facts when it comes time to write the answer. As a matter of fact, being meticulous about the facts always is required on the California bar exam essays. I don't think you'll look at a single video clip in which I advise you to blow off the facts. The core of our work together is to sharpen your skills at issue spotting, organization, and factual analysis. And of these three, analysis counts for more than anything else. So let's go and have a look at how I answer this fact pattern. Look at the first part of the first page. Should the attorney have told the police officer anything about the shoes and the ring? Notice how up front I lead with the facts. I explain what happened, and I use that to set up the analysis. I focus on the duty of confidentiality. The attorney knows that the client had stolen the ring and the shoes because of the confession. And the attorney learned this information by a confidential communication with the client. And this duty of confidentiality requires the attorney not to reveal this extremely prejudicial information to anybody, especially to an agent of law enforcement. At the same time, the attorney owes a duty of candor to the system of justice. Here, the attorney cannot actively obstruct justice by personally hiding or destroying evidence. But notice, the attorney isn't doing either of those things. The attorney is merely refusing to give evidence to a police officer who is investigating a crime. And the bottom line is the attorney will not be subject to discipline for refusing to tell the police officer what the officer wanted to know. And by the way, if the result had been the opposite, if the attorney had told law enforcement all about the shoes and ring, he certainly would have been subject to discipline for breaching the duties of confidentiality that he owes his client. Next, we move on to the first question about the grand jury. Should the attorney tell the grand jury that David is threatening to destroy the scraps of shirt? Notice again how I very briefly lead with the facts. I indicate what the grand jury has done, and I lead up front with an acknowledgement that the attorney owes the grand jury a duty of candor, but that he still owes his client a duty of confidentiality, and also a duty of zealousness. So, I focus on the facts. The attorney properly told the defendant not to burn the torn-up, stolen shirt during the meeting, but the client has insisted that he is going to burn it. Again, the attorney cannot actively help the client destroy evidence, but plenty of criminal defendants make all sorts of similar comments to attorneys. The attorney-client privilege would mean nothing if grand juries were free to call criminal defense lawyers to their meetings and ask the attorney questions about representation. So, if this were a slightly different situation, if, for example, the client were threatening to make sure that a witness were injured or killed, then the result would be different. Then the duty of attorneys and other professionals, by the way, to prevent crimes of violence would be more important than the duty of confidentiality. But here, given the facts that are presented to us, the attorney is acting properly by not telling the grand jury anything about his client's possible plans to destroy evidence. Next, we are asked whether the attorney can tell the grand jury anything else about the incidents that we know about. So, I focus first on the initial meeting. Here again, I lead with the facts, and the most important fact about the initial meeting is that the defendant confessed to all of the crimes during that meeting. That communication is as privileged as any communication between an attorney and a client, and the attorney may not tell about it to the grand jury. Also, the defendant makes other damaging comments, like, for example, admitting that he is wearing the victim's shirt, shoes, and ring at the time of his arrest, and also about discarding the ring and his efforts to hide the shoes and the shirt. Again, all of this information is intrinsically connected to the confession. It can't be severed from it, so the attorney has to remain silent about these details also. How about the encounter with the police officer? Here, the attorney can tell the grand jury that he met the police officer outside the jail. Also, he can admit that he didn't tell the police officer anything about the shoes and the ring. These statements would not violate the attorney-client privilege, and revealing that data would be consistent with the attorney's duty of candor owed to the grand jury. So, ultimately, I conclude that the attorney is prohibited from communicating anything to the grand jury about his meeting with the client, but that he may tell them about his encounter with the police officer. And that leaves us with the last question presented, a real short answer question about whether the attorney should continue to represent this defendant. And notice how, up front, I lead with the bottom line. We have not yet seen any facts that mandate a withdrawal. Still, it looks as if it would be prudent for the attorney to get out of this case. The attorney has been consistent in advising his client about how to behave, and the client refuses to follow the attorney's advice. And the attorney has been dragged in front of a grand jury to do what I described as a balancing act between his duties of confidentiality and candor. So, it's possible also that this attorney could be called as a witness at the trial given the encounter with the police officer. So, I think it would be good advice for the attorney to withdraw. And in my own practice as a criminal defense lawyer, I have withdrawn from cases involving somewhat similar, but not quite as stark, facts. So, I think it would be prudent for the attorney to withdraw. But I do not think yet that the ethical laws require him to withdraw. So, This is a tricky question, and you can see that my organization is simple. It follows the call of the question. Internally, I am organizing my analysis around the facts and around the legal duties. This is pretty standard in good essay answers to PR questions.